Welcome to the next episode of Small Business Legal Tips. Imagine your phone lighting up with that uh-oh voicemail or text. Your confidential and proprietary pricing information was just shared with a competitor. The source of the disclosure was a business that was interested in acquiring your company months ago, but the deal fell apart. Although you had them sign a non-disclosure agreement called an NDA, they never gave you back all copies of your confidential information. Now your confidential information is being shared with your competitors who can now undercut your potential bids. I'm attorney Mark Bross of Bross Law LLC. I'm a practicing business attorney, and I've helped countless entrepreneurs protect their confidential and proprietary information by the use of strong and enforceable NDAs. In this video, I'll talk about 8 NDA secrets that you should incorporate into your company's NDA to protect business confidential and proprietary information. I'll go through each secret one by one, and by the end of the video, you'll know exactly how to improve your company's NDA to make sure it protects your business assets. And please, if you'd like to get more helpful legal tips, please hit the like and subscribe button below. It really helps the channel and lets me know that you'd like to receive more information like this. So let's get to it. Secret number 1, clearly define what counts as confidential information. The first secret is that your NDA must clearly define what constitutes confidential and proprietary information. Most NDAs fail to do this because they're too vague or overbroad. If your NDA defines confidential information as all business information, this will likely be unenforceable because it's too broad and vague. Courts will only enforce your NDA to the extent it's needed to protect a legitimate business interests and narrowly tailored to that interest. Any attempt to keep all business information confidential will likely be viewed by the court as unreasonable, since some business information obviously will always need to be public. Instead, your definition of confidential information should include broad categories of information along with specific examples. For example, presuming that this fits, you'd want to say something like, quote, confidential information includes, but is not limited to, business plans, financial records, customer lists, pricing strategies, proprietary technology, product designs, and any other information that is disclosed in writing, orally, or through any other medium that is marked as confidential or would be presumably understood to be confidential by the nature of the information and the context of the disclosure, end quote. A couple of things to note. First, your definition of confidential information should be tailored to whatever information is actually confidential information in your business and you're trying to protect from the other party who is signing the agreement. If your pricing strategies are not confidential but common knowledge, don't include it in the definition. And if you have more information that you're trying to protect, like, quote, new product specifications, end quote, or, quote, software source code, end quote, make sure to include it as part of the definition. Second, no matter what your definition of confidential information is, you want to include some kind of catch-all phrase at the end of the definition to capture any other information that is disclosed or discovered that would be reasonably understood to be confidential, even if it's not marked as confidential. That way you're covered in case something was inadvertently left out of the definition. Secret number 2, identify what's not confidential information. The second secret is that your NDA should specifically identify what information is not confidential information. Although this might sound paradoxical, there are certainly widely recognized exceptions to what constitutes confidential information, and if you don't include them, a court will likely refuse to enforce your NDA as overly broad and unenforceable. Here are the most common exceptions to definitions of confidential information that should be included in your NDA. First, information that is already in the public domain is not confidential information so long as the recipient is not the one who made it public knowledge. Second, information that the recipient already knows is not confidential information, provided that the recipient did not properly obtain it, such as by stealing it from you, or learn about it while he or she was already in a confidential relationship with you. Third, information that the recipient rightfully obtains from a third party is not confidential information, provided that the third party did not wrongfully obtain it from you or was not under a confidential relationship with you. Fourth, information that the recipient independently develops is not your confidential information, provided that the recipient did not use or rely on your confidential information when doing so. Secret number 3, spell out the purpose and the permitted uses. The third secret is that your NDA should specifically identify and spell out the purpose of why the confidential information is being disclosed with the other party and the permitted uses of your confidential information. This is a detail that most DIY templates leave out, and it is perhaps the most critical part of your NDA. For example, Suppose that your business is in discussions with a larger company, call it Company X, about a potential acquisition. Your NDA with Company X should specifically state that the purpose of disclosing the information to Company X is to determine whether your company is going to be acquired by Company X. The reason why it's so important to identify the purpose is so that your NDA can specify exactly how your confidential information can be used by the other party. You need to be as specific as possible in order to avoid potential issues in the future. In the acquisition scenario, for example, your NDA should state that Company X can only use the confidential information you disclose to them for the purposes of deciding whether to buy your company within the next 6 months and nothing else. This prevents the other party from using your confidential information for any other reason that could potentially harm your business. If you don't include a purpose in your NDA, you run the risk that your confidential information will be used in ways you didn't intend. By narrowing the purpose, you make it clear. You can use my information only for this specific purpose and nothing else. Secret number 4, permitted disclosures. The fourth secret is that your NDA should specifically identify and address certain situations where disclosure of your confidential information is allowed. Again, you might think this is a little weird because the goal of an NDA is to stop the recipient from disclosing or using your information for any other reason other than the purpose you are disclosing it for. But there are 2 situations that you want to address in your NDA. First, most NDAs allow the recipient of the confidential information to disclose it to their officers, directors, employees, agents, and advisors who are helping out with evaluating the potential transaction, which are called its representatives. Make sure that your NDA states that the recipient's representatives all have a need to know your confidential information for the purpose of evaluating the potential transaction. Also, your NDA should state that all representatives must agree in writing to be bound by the NDA and that the recipient is responsible for ensuring that they comply with it. Second, there are certain disclosures that are required by law or legal process, such as court orders, summons, or government laws or regulations. Your NDA can't stop the recipient from complying with the law or any court order, but your NDA can require the recipient to provide you with prompt notice of any court order if it's legally allowed to do so. This will give you the chance to challenge the disclosure of any confidential information with the appropriate court, or at least require it to be filed under seal in order to preserve its confidentiality. Secret number 5, set a reasonable time limit. The 5th secret is that you want to set a realistic and reasonable time frame for how long the restrictions in the NDA last. Like all restrictive covenants, courts will only enforce an NDA to the extent it protects a legitimate business interest and the restrictions are no more than what is reasonably necessary to protect that interest. Now, many business owners will ask, how long is reasonably necessary for my NDA to last? That's a great question. But like many legal issues, it's complicated, and it will depend on the type of information that's involved and the law that applies to the NDA, which we'll talk about in a moment. For sensitive trade secrets, the restrictions in the NDA should last for as long as the information is actually a trade secret under applicable law. This can be a really long time. Coca-Cola's recipe, for example, has been a trade secret for over 100 years. So if Coca-Cola's recipe was disclosed to someone 50 years ago under an NDA, the restrictions of non-disclosure would still be in effect and they'd still be prohibited from disclosing Coca-Cola's secret recipe. But for general run-of-the-mill confidential information, such as your financial information or business strategies, the time period should be much shorter and will depend on what your business actually needs. So think carefully about the life cycle of your information and set a timeline that makes sense for this run-of-the-mill confidential information to be kept confidential. 2 to 5 years is common for this type of information, depending on the information involved in the law that applies to the NDA. The key is that your NDA should distinguish between trade secrets and other types of confidential information and have different time periods for each one. For trade secrets such as source code or formulas, the time period should be indefinite, so long as the information remains a trade secret. For other confidential information, the time period should be between 2 to 5 years, depending on what your business actually needs. Secret number 6, return or destroy. The 6th secret is that your NDA should have a requirement that the recipient must return or destroy all your confidential information upon demand, or in any event upon termination of the NDA. This provision ensures that you will retain and regain control over your confidential information if the potential deal breaks down and minimizes the risk of unauthorized use or disclosure after the agreement ends. This is the key clause that was missing from the story I told at the beginning of this video, and it is often one of the most negotiated clauses in any NDA. Some of the aspects that are negotiated are whether the recipient is going to be allowed to retain a copy for archival purposes, how long the recipient has to return or destroy your information after the end of the agreement or you request it, and how you're going to verify compliance that all the information has been returned or destroyed. Don't ignore this issue. No matter what the purpose is, you need to plan for what happens to any confidential information that was disclosed after the agreement ends and discussions are finished. Secret number 7, define the consequences of a breach. The 7th secret is that your NDA must specifically state what happens if the other side breaks the agreement, which are known as remedies. This ensures that your NDA has teeth and isn't just a piece of paper that can be ignored. Here are some remedies typically included as part of an NDA. First, your NDA should state that you have the right to obtain equitable relief for any breach or threatened breach of the NDA, including injunctive relief and specific performance without posting a bond. Injunctive relief means that you can go to court to stop the other party from disclosing your confidential information before they do so. Specific performance means that you can go to court to force the recipient to do something to honor the agreement, such as returning or destroying your confidential information upon termination of the agreement. Second, your NDA should also state that in addition to all other remedies contained in the agreement, you also have the right to obtain all other remedies available at law or in equity. This is a catch-all phrase that will allow you to pursue any other remedies that are available for a breach of the NDA by the other party. This catch-all phrase is essential because there are a lot of remedies that are potentially available for a breach of an NDA depending on the circumstances, including potentially lost profits, punitive damages, special damages, and many others. Rather than attempting to identify all the possible damages you can obtain, it's just easier to say that you can obtain all remedies that are available to you under the law or in equity in case there's a breach of the agreement. Third, it's also absolutely essential that your NDA should include a clause that states that the prevailing party in any litigation is entitled to receive their attorney's fees and costs. This ensures that if you need to go to court to enforce your NDA and you win, that you'll be able to recover your attorney's fees. Otherwise, you'll have to bear the cost of the litigation whether you win or lose. In addition to these 3 clauses, you may also want to consider whether your NDA should also have a liquidated damages clause. A liquidated damages clause is a clause that specifies an exact dollar amount that will be paid by the recipient in the event of a breach. For example, you might say in your NDA, in the event of a breach, the recipient agrees to pay you $100,000. However, these clauses can be tricky to enforce. So before you include one, I would recommend speaking with an attorney in your area about including a clause like this to make sure that you can actually enforce it. No matter which of these remedies clauses you decide to include with your NDA, however, you want to include something. By laying out consequences, you would discourage breaches before they happen, and you make sure that your NDA acts as a real deterrent. Secret number 8. Choice of law and forum. The 8th secret is that your NDA should state exactly what state's law applies to the NDA and where any disputes will be handled, which is called the forum. By default, you should choose the state where your business is located as the state whose law applies to your NDA and the forum where all lawsuits will be brought. By picking your home state as the applicable law and forum, you make it easier on you if you ever need to bring a lawsuit or you need to defend yourself in a lawsuit. Recognize, however, that the other side might disagree, and they would prefer their own home state as the law or the forum. If that's the case, you'll need to negotiate with the other party to find a suitable choice of law and forum that both parties can agree to. A couple of things to note here. First, no matter what state is chosen as the forum for your NDA, make sure that you specify that it is both state and federal courts in that location where the lawsuit can be brought. State courts are great for a lot of things. But if the recipient is located in a different state, it can often be more difficult to serve them a summons and complaint in accordance with state law. Federal law often makes this much easier because it's much easier to serve a summons and a complaint. And if the recipient is located in a country other than the US, I recommend that you speak with an attorney about what to include in your NDA. Enforcing an NDA against a foreign national is often very difficult, so you want to make sure to include clauses in your NDA that will make it easier. Second, no matter what forum is chosen, make sure to specify that it is the exclusive forum for handling any disputes and that both parties consent to the form and waive any right to object on the grounds that it is inconvenient. This will prevent either party from trying to object to the form at a later date and trying to get it moved to a different jurisdiction. Third, if you prefer to have disputes about your NDA handled by arbitration rather than court, make sure to have a carve-out in your NDA where you can pursue equitable relief in court. Courts move much faster when it comes to issuing temporary restraining orders or injunctions, and the carve-out would allow you to get one of these quickly while the rest of the dispute is being arbitrated. So there you have it. 8 NDA secrets that will keep your business safe. To recap quickly, Secret 1, define what's confidential. Secret 2, clarify what's not confidential. Secret 3, state the purpose and permitted uses in your NDA. Secret 4, specify permitted disclosures. Secret 5, set a reasonable time limit. Secret 6, a return or destroy clause. Secret 7, define the consequences that will occur in the breach of your NDA. Secret 8, pick your choice of law and forum. In conclusion, non-disclosure agreements or NDAs aren't just empty legal documents that should be ignored. When done correctly, they're enforceable legal agreements that can give you peace of mind and protect your business assets when you're sharing ideas and negotiating deals with third parties. If you found this information helpful, don't forget to hit the like and subscribe button below so you don't miss future episodes of Small Business Legal Tips. And if you'd like me to cover another type of business contract, please let me know in the comments below. Thank you so much for watching. I'll see you in the next episode.